So let me see. We're a couple of minutes past the hour, so I'm going to go ahead and get started. Welcome again to the second roundtable hosted by Child's Voice Project. My name is Suzanne Chester, and I'm going to be your moderator today. Let's go over a couple of logistics since we really want this to be an actual discussion and people, sharing experiences, insights, suggestions would be wonderful. So I'm going to invite feedback and participation from you all at various points throughout the pretty short slideshow that I have. And so please feel free to respond by putting your comment in the chat box or by raising your hand. And Emily High, a colleague of mine with Child's Voice Project, she'll help to field the comments in the chat box. And also, please feel free to ask questions at any time, put them in the chat box, and Emily and I will get to them. So a couple of words, first of all, about my background. From 2014, for 10 years, I directed the Child's Advocate, which is a special project at Legal Aid of North Carolina. And basically, judges in the counties that we serve would appoint attorneys from our office to represent children in cases, complex custody cases, some of which involve concerns like domestic violence, child maltreatment, maybe children with special needs, a parent wanting to relocate. The attorneys appointed by the court were designated to act in the role of child advocate attorney. So that meant our job was to advocate for the child's preferences and to have a traditional attorney-client relationship with that child. Then I stepped down from the Child's Advocate at the beginning of last year and became a co-director at Child's Voice Project, which you see on the screen here. And our mission at Child's Voice Project is to amplify children's voices in custody cases, in complex custody cases. And we promote this attorney advocate model through education, through research, and also through a pilot program providing attorneys for children aged 9 to 17. So our topic today is going to be engaging with your child clients. And I personally learned much of what I know about how to engage with a child client as an attorney from my former clients, from my colleagues at the Child's Advocate, my colleagues at Child's Voice Project, and especially from mental health professionals that I worked with. They gave invaluable suggestions and advice about how to engage with the child client and how to convey some complicated information. So today, although my experiences in the area of being a child advocate attorney, we're not just focusing on that. I want to hear from those of you in the audience who are, guardian ad litems, mental health professionals, attorneys playing roles other than child advocate attorney. And so if you're comfortable, it would be great if you could write into the chat what role you are. It may be that you're a young adult with lived experience in the court system. Anything that you're comfortable sharing with in terms of your role would be great. And Emily will help me to kind of respond or add them up and let me know some information. So it looks like we have quite a few mental health professionals. That's wonderful. We have attorneys representing domestic violence, sexual assault survivors. We have an attorney GAL person. We have parenting coordinators and child access mediators. We have a college student with lived experience. We have court-ordered visitation supervisors. We have a protective parent from U.S. Kids Rights Advocate. We have family court mediators. We have an administrative law judge who presides over special education cases, and sometimes the minor student will testify. We have licensed clinical mental health counselor. So we have a wonderful range of different roles. I'm excited to see that so people from so many different arenas have joined this. So let's keep going ahead with, we're going to focus today on engaging with your client. And so I don't need to read the sections out to you, but they're the 4 areas that I hope to focus on as we go through some different topics. But before we start today, I do want to clarify different terms that I will be using. Probably you all agree that there is a great deal of confusion as to the role of a child's attorney, whether the role is a guardian ad litem, whether the role is that of a best interest attorney who's supposed to recommend what they believe is in the child's best interest, just as a guardian ad litem has a similar role, but does not necessarily need to be an attorney, could be a mental health professional. They recommend what they believe is in the child's best interest. By contrast, a child advocate attorney or a client-directed attorney advocates for what the child believes is best for them. So basically, we advocate for what the child's preferences are by conveying their experiences and the reasons for their preferences. And so this is a pretty dense slide, but the 2 main takeaways are the role of these different types of attorneys and the issue of confidentiality. With a best interest attorney, there is some level of confidentiality, but it's not as full as with a child advocate attorney. With a guardian ad litem, there's a much lower level of confidentiality in that a guardian ad litem, and please correct me if I'm wrong, is generally free to share what a child has said in a report or testifying in court. By contrast, a child advocate attorney is required to keep confidential anything the client tells the attorney unless they have explicit permission to share. So I'd love to get some input from you all for those of you who have clients, whether they may be in the mental health context or in the context of you representing them as an attorney or as a guardian ad litem. It would be great if you could put into the chat box or raise your hands as to places where you like to meet with your client. I know a lot has changed since COVID. A lot of stuff has become via Zoom, but in a pre-COVID and post-COVID world, where are your optimal places to meet with a client? So I see some folks are suggesting local library or their office. Office from an attorney, from a mental health professional. All of the above. I'm referring, I think, to the six different options on the slide. A community center via Zoom. Sometimes it could be in the home, depending on where the client or the court approves. It could be in the home or in the child's home or in the community. It could be in an office or library or mall. Several people are saying all of these options. And Katie notes that if she is a high energy client, they do much better when they can meet somewhere where the child can be physically active while we talk. It could be at the non-custodial parent's home is another option that's been suggested. So let me go back here. Just close out there. So thank you for those suggestions. It sounds like they kind of run the gamut across the board. I personally have some pretty strong preferences about my first meeting with a client. I really like to meet at my office. And the reasons for that is I want to be able to establish the attorney-client relationship early on. And I think actually having, if the parents are able to bring the child to my office, that's optimal, because I do want the child to understand that this is a special relationship, that it's going to be their space to actually talk confidentially to somebody, and it's going to be their space to ask questions, to provide information, and that privacy is assured. They don't have to be, thinking about who might overhear from the next room. I have my client file on the table. They see where I put any notes that I take. And so that's probably my favorite area to at least have the first meeting. I'm interested to know I think somebody mentioned that they like to meet at the home of a parent. Do you ever have concerns about a parent overhearing the conversation, or depending on your role, are you fine with that?
I can step in. I'm Kelly. I'm a court-ordered supervised visitation specialist with Roberts Family Resolution Services, and my role is solely as a supervisor, and I'm not dealing with the intimate speakings with the child. So I'm really there to just ensure that they're safe and they're comfortable and having fun with the parent who has lost custody.
Mm-hmm.
So any opportunity I have to just check in with them, on based on their comfort, and if I have any safety concerns, I take a moment to step out when I know if I have other clients that they're safe. In another room, maybe I take a moment privately to speak to that child out of ear and eyesight from
Mm-hmm.
the parent.
Mm-hmm. Mm-hmm.
But
Mm-hmm.
I have to stay within my role, so I don't ask too many
Absolutely.
personal questions. Yeah, just about the
Right.
present circumstances. Yeah, thank you.
Thank you. That's very helpful. Any other comments from folks who meet with children at one of the parents' homes? So how about school? So I know sometimes attorneys will go to a school to meet with a child client, and that's fine as long as you've really cleared it with the child that they're okay with you coming to school. I know for a lot of children or a lot of clients I've had, it's hard enough being involved in a full-scale custody dispute without their attorney showing up at their school as well. So for those of you who are considering going to a school to meet the child, just be sure ahead of time that you have cleared it with the child, that they are really comfortable with it. Anyone have any comments about having met with a child in the school environment and how it's gone? Okay. In a restaurant, so that's kind of that's often my second choice is, let's say I've met with a client already in my office, or the parent hasn't been able to bring them. Then I'll probably choose a McDonald's that's close to the client's home, and find a quiet area, bring different things that will make the experience more comfortable for the child, like fidget toys, coloring pencils, Play-Doh. Play-Doh is a big favorite of mine, and just kind of separate ourselves off into a quiet area where we can talk. So I don't know how many of you were able to join our first roundtable. Dr. Sloan moderated that one, and they spent a fair amount of time talking about a child-friendly environment and also about building rapport, which is actually absolutely essential to, effectively build rapport with the child client before getting into any of the details about your role, and about confidentiality, to establish some level of rapport. And obviously maintaining that rapport throughout is vital. Because Dr. Sloan already covered that, I'm not going to spend time on building a child-friendly environment or establishing rapport in the non-legal sense. I want to move to the actual ways of engaging with your client and explaining what your role is. So it can be tricky to explain to a child, why they're there. I always check with the parents ahead of time. Does your child know that there's a custody dispute going on and that the case is in court and that judges are now involved? And invariably, they already do know that. So when the child comes to my office, at some point after having established some rapport with the child, made the child feel comfortable, the ways that I will explain my role is by acknowledging that the parents are having problems figuring out where the child is going to live, where the child is going to spend most of their time. I will let the child know that their parents have asked a judge to help them decide where the child is going to live and how much time they're going to spend. So I'm talking about children age 9 and above, and a lot of the examples that I give here are geared primarily to children probably in the 10, 11, 12, maybe 13 range. When I explain why I'm there talking to them, I let them know that the judge has asked me to be your lawyer because he or she really wants to know more about you. And I really emphasize that because I find that children in custody disputes often feel, well, they have a whole range of feelings, but knowing that the judge actually wants to learn more about them can be quite empowering for them. I also tried to avoid using legal jargon. Like I would never talk about the plaintiff filed a lawsuit against the defendant, who, by the way, is your dad, and now we're in court. I try to avoid using inflammatory language. Obviously, I don't talk about one parent suing the other. But my focus is on the judge's interest in learning more about them. I would love to hear from you all. How do you explain, like, for example, as a GAL or as a supervisor of visitation, or in some other court-appointed role, how do you explain your role to the child? And again, feel free to raise your hand, just talk, or put it in the chat, whichever you're more comfortable with. So is there a I am the child's friend and support team. Chris explains their role by letting the child know that. I like the idea of a support team. I think that idea of the child being part of a team can be really helpful. In my work representing child clients, I think the sense of being aligned with the child on a team can be quite empowering. Any other input from folks about how you explain your role? Any GALs who want to explain or just talk without putting it? Okay. In Kentucky, I'm a Kentucky GAL and best interest attorney, so I usually talk to them about the judge wants to understand the child and what would be best for them. Great. Cynthia says, I'm there to make sure that they feel safe and supported. By the time I meet the child, they've been through litigation already, so they have some understanding. That is the same as my experience. Most of the children I represent, the litigation is not just starting. They may have already been in it for many years, actually. Rachel lets the child know I'm there for them during this process. Thank you. I will often ask the child what they already know about lawyers, court, judges, etc., and then build off their knowledge. That's from Katie, who's a child advocate attorney. Kelly says she's there to ensure their safety and well-being. Thank you for this input. Any comments about ways that we're presenting our roles? Any suggestions from mental health professionals about how might be a good way to convey the role of an attorney? Okay, let's move on to the next slide. So when I'm talking about my role to my child clients, I really do emphasize that my role is to advocate for what they want. But I don't get into, any of the details like hearings or trials or motions. I try to completely avoid legal jargon. At a later point with older clients, it may be necessary to get into more detail, but I certainly don't do that at the beginning. Then I let the client know that after the judge finds out what everyone wants, the judge is going to make a decision. And so I think that's really important for two different reasons. One, I don't want the child to think that their preference or their wishes is what's going to determine the outcome. Because, I mean, the research shows in general that that is a very heavy responsibility for a child if they think that their input basically determines the outcome. So I try to emphasize that is not the case. I also want to manage expectations. If a child is very wedded to a certain outcome, I want them to know that what their preferences are and their experiences are one part of all of the evidence that the judge is going to consider. And I really emphasize that I'm not there for their mom, I'm not there for their dad, and that it's not their mom or their dad or the child who's going to end up making the decision, that it's the judge. I try to keep pushing it back on the judge, as the judge is the one who's going to make the decision, because unless the parties settle, obviously it will be the judge who makes the decision in the vast majority of cases. Since I know this is a sensitive issue about making sure that the child doesn't feel responsible for the outcome, anyone have any suggestions as to how to minimize the child's potential sense of responsibility for a decision? And I welcome you just speaking. or comments in the chat, whichever you're more comfortable with. Okay, I don't, oh, oops, there is one there. So Steph says, when working in a custody evaluation context, I like to explain that courts need help making decisions, and I'm a person that understands families and can help judges understand the special and unique parts of you, the child, and your family. Great. I really like that. That idea of the attorney or whoever the helping professional is helping helping the court to get a fuller picture. So let's talk about confidentiality and explaining lawyer-client confidentiality to a child. So what I find is children of all ages, they understand the importance of rules, and they understand that there's consequences for not following rules. I emphasize, especially with children who are a little younger, that lawyers have a lot of rules to follow. And that I'll tell them, I can get in serious trouble if I don't follow the rules of being, of keeping what my client says confidential. When I'm speaking with a younger child, I'll use the word private instead of confidential. I'll tell the child, this means that I keep whatever you tell me private. I avoid the word secret because of its connotations. But I do emphasize to the kid that one of the most important rules is I can't share what they tell me with anyone else, including their parents. Then I also talk about the fact that if they allow me to share something, if they give me permission, then of course I will share it if I think it's going to be helpful for my client during the litigation. At the end of each meeting, I make a point of checking with my child client, is it okay with you if I share this with your mom or your dad or with an attorney in the case? And I'll actually write it down because I want to be sure I get it right. It's probably one of the most important things, that the child feels like they can trust that I'm not going to share information they have confided in me without their permission. The whole issue of being a mandated reporter as a child's attorney also comes up. And I won't get into, all the differences across the country with the laws relating to mandated reporting. But what I'll do before I meet with the child for the first time, I'll review the file and check whether or not there is a history of either allegations or findings of domestic violence, of neglect, of child abuse, or some kind of maltreatment. And in those cases, I'll always raise the issue of my duty to report in certain cases. How I'll present it to my child client is the only time I do have to share something you have told me is if you tell me that someone at home is hurting you. And I don't get into any more details than that. But that way, if it does come up that the child discloses something to me and it has not been reported and meets the definition of needing to be reported, then the child isn't blindsided by suddenly learning, oh, this person who's told me for the last several months that everything I say is confidential, is now sharing what I have told her with other people. I try to make a game of it when I want to check that my clients have understood what I've said, because some of these concepts are tricky enough. And so, I'll playfully kind of talk about, well, what's the most important rule I have to follow? And I'll have them do the same thing with me to check that I've understood what they have said to me. And I always remind my child clients about confidentiality every time I meet with them, because a lot of these children, as you know, are meeting with multiple different professionals, and they don't necessarily remember from meeting to meeting. I would love to hear, is there anyone out there, maybe somebody with any young adult who had an attorney as a child, and whether or not confidentiality made a difference, or any mental health professional or GAL who wants to talk about some of the challenges relating to the issue of confidentiality. So I've given a smorgasbord of options.
And Suzanne, it does look like there's a question in the chat about whether you rediscuss this each time you meet with a child in case they've forgotten.
Yes, I do. And thank you for bringing that up. That I think is super important. I had one child who had been meeting with several different professionals, and she was almost 9. She was a little younger than the children we usually serve. But I asked her, "Do you remember what my role is?" And she said to me, "Are you my therapist?" And so I always remind children, especially younger children, of my role. And I remind children, regardless of their age, of my duty of confidentiality at every meeting. I really don't expect them to remember. And I think it can be reassuring to hear it said more than once.
Well, I can speak on that if you would like.
That would be wonderful. Please do.
This is Rachel. I work for Cynthia with Robertson's Family Resolutions. So depending on the role I play. So when working with Cynthia, that confidentiality side of things doesn't really come up quite so much. I do in the beginning let the child know that if there is something that they would like to talk to me about, in private, then I can do that. A lot of times we're doing fun things with the parent. So I set up a safety net. We figure out before the parent comes a safe word, so that they can, if they, or if they're feeling intimidated or unsafe, they can come around and I will stand in between them. I allow the child to use me as a buffer, I guess, for that kind of a role. And that's never discussed with the visiting parent, and they know that. And I think that automatically sets up a reminder, and I remind them in many cases, if you remember, if you're not feeling comfortable or if your parent's doing something or it's not okay with you, you can always come to the side of me. You don't have to say a word. I get it. Right. That lets me know without having to have a conversation. As an individual therapist, I remind a lot in sessions because most kids are fed up with the whole shebang by the time I get them as an individual therapist. Especially when they're teenagers, they're pissed about it. They're done. They don't trust their dad. They don't trust their mom. They can't stand this, all these phone calls. I'm done. We get that kind of a response from these guys all the time. So I remind, well, I'm not going to tell your mom this is just between you and me. And you'll notice once that's said, you can see the demeanor change when they remember. They drop, the shoulders drop, they kind of lighten up. Oh, okay, So, and being able to honor that space of, yep, I'm not going to tell your mom about anything. I'm not going to tell your dad. This is just between you and me. And if you don't want to say anything, you don't have to. It's not a pressure thing. It's an optional thing. Yeah.
Right. That sounds wonderful. I love the way in the supervised visitation context, the child doesn't have to say anything. They just need to move over closer to you, and that sends the message without them even having to articulate it. But thank you very much for that. So managing expectations, that's a big one. I want the child to have a very full sense that I am there to advocate for them. I want them to feel that their wishes, their experiences really count, and that I'm going to really be listening to what they tell me. So many of the children that I have represented, you know, they have already met with Child Protective Services, they've met with some other court-ordered professionals. For some of them, not all by any means, but for some of them, little has changed. And they're eager to have a sense that somebody is actually just going to advocate for what they want. And I let them know that we're going to be meeting regularly. As you all know, some of these cases go on for at least a year, oftentimes more. And, you know, it takes a while to get to know our child clients. And like any relationship, it develops over time. As they develop trust and we get to know the child better, and they really get to understand that what they're sharing really is confidential. One thing that I think for me helps to manage expectations is to make heavy use of my role as a counselor at law. So let me give you an example. So as you know, as child advocate attorneys, we don't just parrot what our clients want. We really do counsel our clients, and we help them to understand the likelihood that a judge is going to order what they really want. So, for example, I'm thinking about a client who clearly needs therapy, but is really refusing to get it. The parents are having a hard time getting the child to receive some kind of therapy. And let's say this same child, about 16 years old, also wants to start doing driver's education. So I will let my child client know that judges really like therapy for children. If this goes to trial, if we have to talk to the judge about it, I can tell you almost definitely a judge is going to, you know, require that you attend therapy. And, you know, we can talk about ahead of time if it's ordered, what kind of therapist you would like to see, things like that, if you have to. But I'll also let them know, you know, if we go to court and you're already seeing a therapist, that's going to give a judge a good sense that you've responded to what your parents wanted you to do and what they felt was needed. And maybe then we can actually get you to be allowed to start driver's education. So ways of counseling the clients so they can actually see, sometimes there's obviously some strategy to it, but a way of seeing how it's going to look to the court and how a court, most importantly, is going to respond. Anyone wanting to give some feedback about managing expectations in either the therapeutic context or the legal context with a client? Jessica, I see you're on the line. Any suggestions, or Tia or Katie? These are all former colleagues of mine who are child advocate attorneys. Any suggestions about how to manage your clients' expectations?
Suzanne, this is Katie. I don't have anything other than what you've already shared, and I think my colleague Jessica does a really great job of this. She really talks about, you know, the we're going to try to be the child's voice and advocate for the child vigorously. However, the judge is the ultimate decider of everything. And I feel like she does the best job I've seen of anybody that does that. And I really follow her model.
Thank you, Katie. Chris made a comment here, kids don't trust the system. Any suggestions, Chris, as to how to build that trust in whatever role you are engaging with the child in? Anyone with any other thoughts about managing expectations?
I would
And-
say, just, yeah, that to Chris's point, that sometimes kids don't trust the system and they have good reason for that. And so when that is the case, I'm not always seeking to change that. I'm looking to help them develop opportunities to have a sense of self-efficacy. And so, you know, when there's a lack of distrust, it's typically because there have been things that have happened to the child that have resulted in that distrust. And so looking for opportunities and what we can impact and how we can do that productively is typically what I would focus on at that point.
Thank you. That was Dr. Steph. And I completely agree that I don't take the tack of, you know, trying to tell the child when you need to trust the system. There's many reasons, as Steph said, why they may not trust the system. But by our actions and our words as their advocate, I think we can build up a level of trust, at least in our role, even though it may not extend to the whole system.
And I think something else too, this is Jessica with the Child's Advocate, is I do my best to explain to my children clients like what the judge goals are, meaning, you know, the judge wants you to have a healthy, positive relationship with both of your parents. And the judge is going to try to figure out, okay, what can we do for you to get there? So again, trying to give, you know, my children clients the full picture. I think it's really helpful with, you know, our representation with them.
Thank you, Jessica. I think you touch on a vital point there that regardless of how the individual child may feel about what a parent, they need to understand that the emphasis of the court system is going to be on having relationships with both parents. By the same token, I think when children are able to share with us reasons why a relationship with one parent may be damaged, it can be very helpful in how we're able to advocate for that child, whether it be through getting services in place that are helpful to address those issues. But yes, giving the child an honest picture that while they may not want any contact with a parent, you know, most of the cases that my colleagues at the Child's Advocate and Child's Voice Project deal with are cases with these difficult issues in them. Caroline says, I don't know if this is the best analogy, but for my teen clients, I like to explain my role as counselor at law by using a driver's seat analogy, by explaining they are behind the wheel and I am the passenger making recommendations on where to turn, brake, go, ultimately, but they decide where they want to be or go. I love that example because, well, I think it's just, it's a very visual example, but also ultimately they get to make the decision. Because I think what's really important as attorneys, child advocate attorneys, is we don't try to impose or persuade our client of what they should want. But this way, we can make recommendations, we can counsel, but we ultimately must be faithful to what their decision is. Well, thank you all for these great suggestions. Rachel said, I meet the child where they're at. And Sarah says, I find that if my clients feel like they've had the opportunity to be heard and feel respected, they're more likely to feel that the outcomes are fair, even if they are not an outcome that they wanted. Sarah, thanks for bringing up that point. We're going to talk about that a little more, I think in the next slide, actually. that sense of the child having some sense of procedural justice, that somebody's listened to them, somebody's advocating for what they want. So answering your client's questions, as a child advocate attorney, I feel like I have a really important role to provide my client with answers to questions, because so many children in these situations, they're not getting the full picture. They could be getting a very distorted picture or only half the picture. And so I like to ask them, you know, what questions do you have for me? But in a case many years ago, I decided I would ask the child something a little more explicit, like, is there anything going on relating to all this court stuff that confuses you and you'd like an answer for? Because I had gotten the impression that this child was having a hard time understanding why they were in court to begin with. So as I think a 12-year-old child, she had a strong relationship with her grandfather, her maternal grandfather, while her mother was alive. Her mother had passed away. And then the grandfather was cut out of the relationship with the child, and the father wouldn't allow any contact between the child and the child's grandfather. And so the grandfather had filed a custody legal action in court asking for contact. And so when I said to this child, is there anything that's really confusing you? She immediately asked me why her grandfather had taken her father to court. So I told her I'd do my best to get an answer to the question. And I looked back again at the court file. There was a long history to this case. And it was clear from the file that the grandfather had not been allowed any contact, and that the only way the grandfather was going to be able to get contact was through a legal court order. And so at the next meeting, I could tell when my client walked in, she was waiting for answers. And so I explained to her that really this was the only way that your grandfather was going to be able to get to see you and to visit with you, and, you know, reminding her of, well, she didn't need reminding of the great relationship that she had had. But it really made, I really got the sense that this was very helpful for this child to actually understand the grandfather didn't do it just to make trouble for her father. The grandfather did it as the only way that was left to actually have a relationship with the child. I'm wondering, anyone in the audience want to talk about ways that you handle when a child makes a request for information? Or when you ask a child a question that leads to some kind of a request, how you handle that? Yeah, Chris says, tell the truth and listen. Anyone have any examples of where they've, Hitali says, definitely by affirming to start. That's a great question. I'm glad you asked. Not to be patronizing or fake, but to make them comfortable asking the question. Thank you, Hitali, for that. Yeah, it's so important in our roles not to sound or be fake, or to patronize them, because I think children quickly see through that. And to send them the message, the importance of sending them the message that they're absolutely within their rights, you know, to have these questions, and we want to try to get answers. So building trust within the relationship. When I meet with a client at my office or in a restaurant, wherever it is, I take a few notes. I don't take a lot of notes, but before I start, I ask for permission. I've had clients who, before they were appointed their own attorney, they had their private journals subpoenaed. And so I don't want a child to feel unsafe with me making notes without understanding why I'm making notes. So I'll ask permission and I'll let them know that I put them in the client file and that they're just as confidential as anything that they share with me verbally. Before I talk with a child's therapist, there are some exceptions where I have to talk with a therapist without getting the child's explicit permission, but those are few and far between. But generally speaking, I will write down on a page, you have my permission to talk or you don't have my permission to talk. So I'll talk with the child about why I want to talk with their therapist. Usually it's not an issue, but I want the child to feel like they have this private relationship with their therapist. Now they have a relationship with me, but they still have ownership over that therapeutic relationship. And so they're free to check, you have my permission or you don't have my permission. I find like it's a way of empowering the child to give me permission, but that I don't automatically assume that I have it. Really important in an advocacy role is I always let my clients know I'm going to be talking to your parents as part of my job to investigate all of the case. I'm going to be speaking with their lawyers, especially as we try to get it resolved without a trial. I don't want my child client to suddenly overhear their parents, one of their parents talking to me on the phone and think, well, she told me that everything I told her was confidential. Why is she now talking with my mom or my dad? I think if they know in advance that this is part of our role, I can still assure them I won't be sharing anything, but I will be receiving information from the parents. So sharing clients' position. So from the time I begin representing a child caught up in this kind of litigation, I'm thinking about how can we get to a settlement that will be consistent with my child's wishes, that will keep the child safe, and that will put an end to what's often been several years of litigation. In order to get to settlement, I invariably need to be able to share something about my client's position. And so I will let them know, one, do I have permission to share what they want to see be the outcome of the case? And two, I'll explain to them the implications of me sharing this. So for example, I've had children who think I can talk with dad's attorney and dad's attorney won't necessarily share what I tell him with dad. I can't assume that because dad's attorney has a duty to let dad know, what he's learned about the case. So I will let the child know, are you okay with me sharing this information, knowing that ultimately, the parent will find out. Same thing for purposes of trial. Before I go to trial, I'll actually write down for the client what my understanding is of what the client wants me to advocate for. And that way I feel more confident in what I'm advocating for. And I think that the client feels secure that I've actually understood, what they want. So we're getting up to close to 1 o'clock. I did want to let you know that our next month's roundtable will be moderated by Dr. Sloan, and they'll be exploring multidisciplinary approaches, representation approaches, and that's going to be on Wednesday, March 19th at the same time. And I do want to thank everybody for attending today. I really enjoyed seeing your feedback. I thought it made It made for a very interesting discussion, and it was really great to talk to you all. Nancy, I see you have your hand up.
Yeah, and I'm sorry, I had put in a question about in the therapy setting, how far you, for the mental health professionals here, how far do you go when you have the protective parent in your session? Like they're coming to see you for anxiety, but it's due to court, it's due to court practice, what's going on in custody. um, how far do you go into court issues? Where do you limit that, before going beyond your scope of practice? And do you ever get an ROI to talk to the attorney?
So Nancy, as I understand it, that's a question for the mental health professionals on the call when their client is one of the parents. Is the protective parent in a case where there's some kind of abuse?
Yeah. So if you have the protective parent where there's abuse going, has gone on, they've separated, now they're in the custody process. Like you're dealing with anxiety, you're helping them with their anxiety, of course, but it's kind of an adjustment disorder in that it's due to the court process. How do you handle that? How far into the legal matters do you go without going beyond your scope of practice, and do you get an ROI from the attorney?
So thank you, Nancy, for that question. What I would ask, since we're almost at time, if there's any mental health professional on the call who wants to talk further with Nancy, another mental health professional, about that issue, maybe you want to share email addresses, since we're almost at 1 o'clock, and probably will take a few minutes to discuss that. I've also included my email address. I welcome any comments, any suggestions for future roundtables, and I'm excited. It feels like we're building a community of people who are serving children and families in these complex custody cases. Thank you so much.
Thank you, Suzanne. This was great.
Thank you. I appreciate it.
Thank you very much.
Thank you.
Suzanne, this is Atia.
Hi,
Do you have
Atia.
another minute?
I do.
So I want to go back to your comment about asking your client for permission to speak with their therapist.
Uh-huh.
Have you had a client say no? And if so, what do you do with that response? Do you just never have contact with the therapist? You haven't, okay.
I have not had it, and I've been thinking about what I would do if I got a no. Is, some weeks down the road, I would broach it again with the client, and I would let them know how important it has become to have contact with the therapist, but I've never actually had a no.
Okay, I was
Yeah,
wondering.
I wouldn't just leave it at that, but I guess in part because we know they're likely to say yes. I think it's an
Yeah.
easy way to give them a sense of ownership.
Yeah, I definitely agree with that piece. Awesome. All right, well, thank you. Thanks for the session and have a great day.
You too. Thanks. Bye.
Bye.